Call to order the October meeting of the Cranston City Plan Commission. We do not have minutes for approval from the two meetings that were held in September, the one meeting and the one workshop. As everyone knows, the office is short-staffed, and we had hoped to be staffed up by now, but I guess the lead candidate chose to go somewhere else. So we'll be starting a new search on that. So that brings us right to the Zoning Board of Review recommendations. The first item is Domain Realty has applied to the board to construct a new freestanding sign within the required setbacks from the street and within the area required as to not impede corner visibility.
Gregory Gerton, Senior Planner for the Planning Department. As was previously stated, the subject parcel is located at 846 Oaklawn Avenue. This is a dimensional variance request. It is in a C3 zone general business. The future land use map designation is highway commercial services. The applicant seeks relief from multiple sections in the Code of Ordinance to erect a freestanding sign on a privately owned parcel at the corner of Weaver Street and Oaklawn Avenue. So here is an aerial view of the parcel. The sign is in the bottom left corner of the parcel. Here's a street view. The foundation for the sign that's been constructed already is highlighted in that yellow box. Here is a proposed site layout provided by the applicant. I've highlighted the sign location on that as well. Here's a proposed sign rendering showing the general dimensions of the proposed sign. So the applicant seeks to complete construction of a sign on a corner lot located in a C3 zone that exceeds the standards as written in the Code of Ordinances in a number of ways, such as the location of the proposed sign is located within the 5-foot allowed setback from the property line. The proposed sign exceeds the allowable height. The concrete base of the proposed sign exceeds the height for any construction which would impede motorist vision between a height of 2.5 feet and 10 feet above the center line grades of the intersecting streets at the intersection of a corner lot. The proposed sign is also located within an area of the parcel within 30 feet from the corner of either intersecting street, which is deemed as having the potential to impede motorist vision. And just for a quick clarification, what exactly that means. Essentially, you take 30 feet from the corner in either direction and make a triangle. And so it's been located within that 30 feet, which is not allowed. The applicant has already constructed the concrete base of the sign prior to seeking relief, as shown in the aerial view image taken from the city's GIS. And the comprehensive plan does not contain any language which would address this proposal in any way, either favorably or negatively. So staff finds that the hardship from which the applicant seeks relief is not due to the unique characteristics of the subject land, nor the general characteristics of the surrounding area. Additionally, staff believe that granting this variance request could impair the intent and purpose of the zoning ordinance by way of creating a potentially hazardous circumstance for motorists exiting Weaver Avenue onto Oaklawn Avenue. Planning staff saw additional guidance from the Department of Public Works Traffic Safety Manager, who advised planning staff that the erection of this sign has the potential to impair motorists' view of Oaklawn Avenue while exiting from Weaver Ave. Our recommendation is due to the findings that the application is neither consistent nor inconsistent with the comp plan, and that it would alter the character of the neighborhood by way of creating a potential hazard for motorists traveling on both Oaklawn Avenue and Weaver Avenue. Staff recommends the Plan Commission forward a negative recommendation on the application to the Zoning Board of Review.
Thank you, Mr. Gerton. Would the applicant like to be heard?
My apologies. Is that better? All right. Sorry about that. My name's Joe Carnavale. I'm an attorney with Savage Law Partners. I represent the applicant owner Domain Realty LLC. So really, there are two issues to be addressed before you this evening. First, based upon Mr. Gerton's recitation of the staff report, I'll go ahead and start with the issues related to the sign base itself, or in the structure, I should say. So first and foremost, with respect to the base, per the IBC codes and the applicable ordinances, the installation of the base as it sits today, with nothing else, is not an installation or a modification to the property requiring any building permit to begin with. Secondly, when we evaluate next where the sign is located in reference to the property lines, the signage itself that is going to be attached to the erected steel in the plans that are before the board, the sign component is separate. We're dealing with right now the steel structure itself. And in this C3 zone, the steel, any structural setbacks on the property per 1720.120, it's 0 feet from the front, 0 feet from the side. So my client is within its rights to build right up against the property line, notwithstanding any dispute on the measurements from which the base is located from the property lines. Now, with respect to the staff report, there are some issues with respect to the application of the 30 by 30 road setback requirement. Weaver Street, for anybody that's not aware, is a paper street. There is one house located behind 846 Oaklawn Avenue. The Weaver Street does not connect to the neighborhood in the back, so there is essentially access for one vehicle driver on a daily basis. I understand that with the Tommy's Pizza business, oftentimes on busy weekends and nights, there might be people parking on the street when they can't fit in the Tommy's Pizza lot. However, the usual daily use of that road is for one single family residence. So to adopt a recommendation saying it's a safety risk, it's simply stated it's not. There's hardly any traffic, if any at all. The base, the height of the base as it sits today is lower than any car window that would be passing by and entering or exiting Weaver Street. There's simply no obstruction to the roadway whatsoever. What I will circulate for admission, and forgive me, I only have one copy of each of these images, but they can be passed. Pictures of the sign for Tommy's Pizza, which is directly behind where my client's proposed structure and later signage is located. The Tommy's Pizza sign is no higher than 72 inches off the ground, and you'll see in the photos there's extensive shrubbery growing underneath it. There are also images of the Lucky Mart sign, which is 50, 75 feet down the road, and later the sign for the old gas station that remained on that street corner. So obviously we take issue with the contention that the proposed structure and signage does not fit with the character and fitness of the surrounding neighborhood. This is a very commercially settled street. There are a multitude of signs of this size and even larger in the immediate vicinity. And one of the images I also provided is the signage for 965 Park Place, right across, right out the way that the school buses utilize for access in and out of Cranston West. And you'll see from that signage, there's extensive shrubbery underneath. There is signage within the 2.5 foot to 10 foot area that is supposed to be restricted. So it's certainly relief that has been granted on numerous occasions within the city, and nothing we are looking for here is extraordinary by any sense of the imagination. And I'll also add that the issue pertaining to a unique characteristic of this property. The fact that this is a paper street with one single family residence behind it, which I'll add further, my client is in the process of purchasing. Domain Realty will own that property and close on that property within the next month to 2 months. So to look at this intersection and, foreclose on the ability to put signage there based upon there being one single family residence currently existing, I think is just kind of a stretch of a position. And we're asking that for the planning board to issue a positive recommendation to the zoning board on the application for this relief set forth.
Okay, thank you. Questions from the commission members? Commissioner Frias.
Thank you, sir. I haven't been able to look at your pictures yet, so I may come back to you and ask about your pictures, but I wanted to ask you about you have two requests before us. I want to ask you about the one I don't think you addressed, which was the
application of the site plan review.
yes, the waiver of the
Correct.
yeah, so could you address that first?
So, in that, I want to be clear, that is separate and apart from this sign issue. That has nothing to do with the requested sign permit. That's related to building permits specifically for the interior of the structure on 846. And we are not asking for a waiver of site plan review. Our position is that site plan review is wholly inapplicable. 17.84.20 sets forth the application, the applicability of site plan review for any property developments. And what my client is proposing as far as his interior only renovations go, do not touch on any of the subsections A through E as to what is applicable to site plan review. And we've been, essentially, he's been stonewalled as far as getting permits issued to carry out the interior build out of 846 Oakland Avenue.
Part of my interrupting, Commissioner, I'm going to be presenting on that as well. Just after this, I figured we would hear the sign and talk about that first and then go on to the DPR.
I apologize. I thought we were taking
all
this
right.
as a group.
Nope, no problem.
I'll save my questions about that. And you're talking legal stuff, so I'm gonna have to probably hear some more about that. On the sign thing, you indicated that there are other similar signs in that area. There are other signs on that road that are similarly situated?
Correct.
Okay. Are any of them near an exit to the street? Because I walked the area, because before coming here, I actually decided to walk the area and drive
Mhm.
where you're, try to see if I could, what the situation would be. And so I did notice a lot of signs pretty close within I think the 30 feet, but I'm not sure. Are there signs that are right near the entrance and exit of a parking lot or street?
Yeah, no, absolutely. There
Okay.
are. And, one of them, Tommy's Pizza right there, is literally on the opposite side of the Weaver Street roadway.
Okay.
And then the other one related, the gas station that's been demolished, but the sign is still standing.
All right. If the witness wants to testify, he can, but I was just, it's okay. I saw the pictures. The other thing is, so when I drove there and tried to look, inherently, I have to move up. Like what I mean, like I want to take a left turn. I have to basically move up and go beyond the sign anyway. I'm not going to make a left turn before going up and I'll have to move past the sign, and I don't go into the street. That was my personal experience. Do you have any sort of analysis by an expert on traffic? Because we're getting we have a statement from our own traffic person saying it's a hazard. So I was just wondering if you had anything.
Unfortunately, we did have somebody lined up, but he was ill and couldn't make the hearing.
I assume he'll make the zoning board hearing. Your sign, what purpose is the sign for? Is it commercial?
Eventually, yes.
So it'll, in your opinion, is it going to like promote economic development in the city?
Oh, absolutely. Once, for better or for worse, once we can finally get the building permits issued for the interior build out, there are proposed commercial uses. And by way of history, back in 2021, this property, which was previously zoned residential, was rezoned C3. So there is an expected and anticipated commercial use of the property.
Is there any? There's nothing in our comprehensive plan that specifically deals with signs. As the staff indicated, and I've gone through the comprehensive plan. You can do a word search, look for signs, you're not going to find it. Is there anything in the comprehensive plan that you can cite to, whether it's economic development or something else? To give, because we're supposed to give a recommendation in general to say that it's consistent with the comprehensive plan. So do you have any particular provision in mind?
Not off the top of my head, and candidly, I'll provide another brief history lesson here, just for the group's benefit. When my client originally submitted the permit package for this structure, what you see in your package this evening was not the original plan. It was just the steel structure to be erected with signage to come later. Mr. Peichel in the building department rejected that from my client, and he indicated to him it has to all be put forth as a sign, which we disagree with, but my client was trying to move things along to get everything completed and get, the steel out of storage and get it erected so that, the property could be further developed. So, as we sit today, I can't represent to the board, and I don't believe my client can, that we know specifically who the commercial tenant would be that the signage would represent, because that was always anticipated later on once the property was completed, once we had leasing done. I can tell you my client owns the plazas directly next door for quite a span, and they're all at capacity with commercial tenants, various different types of businesses, and this would just be an extension, so to speak, of additional commercial tenants in that space. So ultimately, there will be an economic benefit by nature of the signage for the commercial tenant, but I can't tell you today that we know with any specificity who the tenant specifically will be.
Okay, thank you.
Other questions, members of the commission? I just had one, to the best of your knowledge, are there any developable lots, to the south side of Weaver Street?
To the best of my knowledge, no. When I last looked at the overhead map, it looked like all of the parcels were spoken for as far as development and structures and whatnot go. That's to the best of my knowledge as we sit today.
Do you know what's located on those parcels right now? I'm not familiar with the particular street.
On the south side of Weaver Street. Do you mind if I take a moment to pull up a map so I can?
Absolutely, thank you.
So to the south side of Weaver Street, there's Tommy's Pizza, Lucky Mart, Stefania's Boutique. And then across the way, there's that long rectangular building that has a salon and a bunch of other small businesses located within it.
I was specifically interested in the ones that are directly adjacent to Weaver Street.
Oh, so directly adjacent is Tommy's Pizza and Lucky Mart. We have them in fact. And
Is there an exit from the parking lot onto Weaver Street or not?
No,
There's no curb cut or anything like that.
okay. Oh, okay. Okay, so yeah, there is a curb cut at the rear of 846. And again, that plan that's on the screen right now is an old plan, but the curb cut still exists.
Okay, thank you.
As the property does help the board is the property is currently situated and laid out. The parking is directly in front. And, right, my client's additional parking, my client also owns the parcels directly to the north of 846 with significant parking.
Okay, so would you maintain then that those people who park in Tommy's Pizza have and could use Weaver Avenue for egress to Oak Lawn Avenue?
Yes, they do.
Okay,
If I could jump in quick, Chairman, there is no curbing on Weaver Ave, so there is every right for a vehicle to leave the parking lot onto Weaver.
okay, thank you. Okay, that's all I have. Okay, other questions on this matter, and then we can move on to the second part. Okay, thank you. Actually, I guess, why don't we vote on the first section first?
Could we have a quick discussion or are we doing
Yeah,
public
absolutely.
comment?
No, absolutely.
On this one, so, when I first looked at this, I was thinking I was gonna vote no. But I decided to go out there and see for myself. And I did drive in that parking lot, in Tommy's parking lot, and try to get out from Weaver onto the street. I looked at where the sign would be, and I naturally would not make a decision to take a left turn from where the sign is. I would move closer. So I'm not convinced that that's an impediment. But the other problem is, I think they're right, is that there are other signs basically similarly situated all down Oak Lawn Avenue. I'm uncomfortable with treating people differently like that. On economic development, I know there's nothing in the comp plan about signs, but we do talk about promoting job growth. And signs are a part of advertising for commercial businesses. So it's a close call for me, but I'm going to err on the side of doing a positive, of not going to vote in favor of this. This is the bottom line. And if my colleagues voting, vote with the staff wants, that's fine. But personally, I'm not. It's a close call. I would have preferred to have your expert here on traffic safety. I hope I'm not making a mistake, to be honest with you. But when I drove in that area and did it, I did not see that sign being an impediment. But that's me, and that's my 2 cents. Sorry to take so long in talking about it.
Not all, yes, Matus.
I'll add some 2 cents as well with Commissioner Frias. Just looking on Google Maps and doing a quick measurement from the roadway to the sign at Tommy's Fine Italian Food, it is 30 feet setback, but outside of that triangle that we have been talking about, I don't know if that makes a difference at all.
So Tommy's is at 30 feet and what they were within 5 feet of the 30 feet?
I have not measured the sign that the applicant is speaking about, but it is exactly 30 feet from the intersecting point. The
Oh.
Tommy's Pizza sign, yes.
Oh, okay. And his is, do we know what his number is exactly?
About 7.5 feet.
So it's 7.5 feet within the 30 feet approximately?
The sign applicable to this application is about 7.5 feet back from the curb line,
Okay, and Tommy's is 30 feet?
30 feet.
Wow, doesn't look like that visually. I'm sorry. Okay. I know you got the map in front of you and you're the public work guy, so you know more than me.
I don't think that's true, Steve.
Okay, any further discussion? Then I'm going to ask if there's anybody online who would like to be heard on this matter.
I'm saying no public comment, Mr. Chairman. A reminder to the public that they need to use the raise hand function in Zoom in order to be heard.
Okay, thank you, Mr. Lima. Unless there's any further discussion on this particular application, I'll entertain a motion. Commissioner Lanfear.
Mr. Chairman, I would move to accept staff recommendation.
Commissioner Lanfear moves to accept staff recommendation, seconded by Commissioner Barbieri. All in favor, please say aye. Opposed, nay. Okay, let's see, Commissioner Exter and Commissioner Frias vote nay. 2, 3, 4, 5. Okay, 5-2. So the motion passes.
Onto the second part, the second ask from the applicant. Also for 846 Oak Lawn Avenue. This is a development plan review waiver request. The applicant seeks relief from development plan review. To the best of our knowledge, we haven't had an applicant request a waiver from this required process such as this, nor has this request ever come before the zoning board of review. The signage request is not part of the development plan review process. The conversion from a single family home into a commercial use warrants the development plan review process, which the applicant has already begun at the pre-application level. With all applications, the committee reviews circulation, lighting, landscaping, drainage, parking, etc. At this time, the development plan review committee still has unresolved issues with this residential conversion proposal that have yet to be addressed. Therefore, staff recommends that the city plan commission forward a negative recommendation on this waiver request to the zoning board of review.
Okay, would the applicant like to be heard on this part?
Very briefly, thank you. With respect to the contention that there are unresolved issues, one, my client would like to know what those are. Those have never been relayed to him. He's gone through the process. He's attended meeting after meeting. There were changes to plans that were made on request of certain individuals within the site plan review process. But at the end of the day, those development plans were abandoned. And he had submitted 2 different building permits earlier this month. First was for the commercial, where he removed all of the exterior modifications that would have warranted site plan review per 178420. When that was stopped by Mr. Rodeo, he attempted to submit a permit just for interior residential renovations so that he could begin carrying out the interior structural work for the beams and for the roof supports. And again, that was stopped without explanation. So as it relates to any unresolved issues, our contention is that they've never been relayed to us. We don't know what they are, therefore we don't know how to address them. But regardless, in light of the most recent permit application for simply interior existing residential renovations, that was denied, referencing site plan review. However, site plan review is not necessary per 178420. And I have nothing further on that unless there are questions on this novel issue of first impression before the board.
Commissioner Frias.
So going back to my first question, really, this is more for the staff or for, I know the solicitor's not gonna like this. Could you, I just want to understand, is his argument, this is not applicable under 1784 dash, I believe, 20, he said. Okay. It's not because, again, why is it specifically not? What language in there says that this is not applicable? Because you're only doing stuff in the interior? Is that what it is?
Stuff on the interior, no modifications to the exterior site, and 178420 sets forth 5 specific categories within which site plan review is applicable. However, interior renovations to the existing does not fit into any of those 5 categories. And without a catch-all provision saying anything else we deem applicable should go to site plan review, there's really nothing that states in the law that site plan review controls.
Could you tell me what those 5 categories are? You don't have to read them word for word, just kind of generally if you can.
So, non-residential development within 200 feet of a residential district, non-residential development within 200 feet of a residential district which proposes new structures, multifamily development, a change in use that would in a 3-year period involve 20% of the property or 15,000 square feet, require 6 or more additional off-street parking, employ different materials or processes, and then finally, subsection E, a development proposing a drive-through.
And what is this building going to be used for?
Eventually, once there's a C of O issued for a commercial use, commercial, but as it sits today, it's an existing residential use. Now, the property's been rezoned. However, that makes the current use as residential a legal non-conforming use, and that non-conforming use has not been abandoned.
Thank you.
Okay, other questions, members of the commission? Commissioner Lanfear.
Thank you, Mr. Chairman. I just want to be sure I understand. Permit use is planned to be commercial. Is that correct?
Correct.
But you are arguing that the project, that the development review is not applicable because it's residential.
Correct, because the commercial development has not been put before the planning or zoning board yet, or the building, the commercial permits.
But
What's-
ultimately, that commercial use would not involve any residential use.
Ultimately, yes.
Thank you.
Go ahead.
With the commercial, they will not be much other to some the existing stuff. All the parking, everything is one. So the commercial, there will be no modifications to the site. So it would not be applicable for the commercial use.
Yes, Commissioner Matthews.
Section 17.84.30 is titled exemptions, which is what's exempt from DPR. What I can mostly conclude is applicable here is B, modifications to existing non-residential structures. However, it says where there is no change in use or area. Is that true? There is no change in use?
There's no change in use until a C of O is issued for a commercial use. That is when the use changes. Unless and until there's a C of O issued for commercial, it's still considered residential.
Okay.
Well, for me, this is a conundrum because the applicant does state that it's currently residential. There will be a change of use to commercial. But we're not at that point in the application process yet. I just need to clear it up in my this brain of mine.
Yeah, no, I believe what you just stated is entirely accurate. And, right now, there's been various applications for permits submitted because absolutely nothing has been able to be done at the property for the past 18 months at least. So we're trying to move forward at least with limited interior renovations so that work can commence while the rest of the plan is put together and brought as necessary. But as it sits today, and back to your point, it's still a residential use. It's a residential use that has not been abandoned. And that's the reason for the partial interior residential building permit application.
Okay, but there will come a point where development plan review is engaged, right? When the purpose of the property changes, is that how this works?
Yeah, yes, that's a fair assessment.
Okay, thank you. Yes, Commissioner Lampier.
Can I just ask a procedural question of our solicitor? Is this a matter, the applicability of that? Is that something that our administrative officer would decide? And is it properly before the commission or then properly before the zoning board to decide that issue?
So the reason why no one has ever seen this before is again, because in that section, it says that development plan review is a condition precedent to go to zoning. So and then if you get denied from development plan review, then you have the right to appeal to zoning. So they're kind of asking the zoning board to waive something that they would ultimately be the appellate board to do. So at the end of that section, it specifically says that development plan review, you have to go to the development plan review if it's determined by the administrative officer that you have to go. And then if you don't like your decision, that can be appealed to the zoning board. So that's why you've never seen that. What they're contending is that they can go to the zoning board first to tell the development plan review that they're not needed. Does that make sense?
Is there a way, since obviously the parties don't agree, that development plan review can just be on paper denied so that the
That's,
applicant
yeah, I mean, that wouldn't be this board's jurisdiction to request. It just wouldn't, or the zoning board can't say development plan review, you deny, you have to go through the process and either get denied or get approved.
This, to me, I'm not sure that I've ever seen a case like this, so, but please forgive the confusion. Well, let's continue with the recommendation.
So at this time, the committee still has unresolved issues with this residential conversion proposal that have yet to be addressed. Therefore, staff recommends that the city plan commission forward a negative recommendation on this waiver request to the zoning board of review.
Let me ask if there are any members of the public with us this evening online who has a question or comment to make.
There is no public comment.
Okay, thank you. Well, in that case, well, yes, Commissioner Frias.
Unless I hear something from my fellow commissioners, I'm sorry, I'm not going to agree with your interpretation of this. This is a pretty novel interpretation of this. I'm not an expert in this area. Mr. Marcella certainly has more expertise on this. I think this is a pretty unusual request you're making. I don't feel comfortable granting it because I don't completely understand how it would work, and you're going to end up in a commercial use anyway. So I just don't feel comfortable granting the waiver because I just don't think you got the best of the legal argument on this, but that's my 2 cents.
Okay, thank you, Commissioner. Any other questions, comments? If not, I'll accept a motion. Motion made by Commissioner Barberi. To accept staff recommendation. Second. Okay, seconded by Commissioner Mancini. All in favor, please say aye.
Aye.
Opposed, nay. The ayes have it and the motion passes. Next item. Susan P. Sparks and Matthew P. Allred and David Sisson have applied to demolish an existing garage and construct a new garage with a rooftop deck connected to the existing single-family dwelling at 15 Taft Street.
So as was previously stated, the subject parcel is located at 15 Taft Street. This is a dimensional variance request. The zone is A6, residential, single family. The future land use map designation is single family residential, 7.26 to 3.64 units per acre. And it's to allow the construction of a new attached garage in place of an existing detached garage within the front lot setbacks in an A6 zone. Here is just an aerial view with a zoning overlay on it, showing that all of the surrounding neighborhood and blocks are of the same zone. Here is an aerial view. On the left is a zoomed in image of the subject parcel. You can see the garage at the top left, the existing garage at the top left of that left image, and the right is an aerial view of the block that the subject parcel is located within. Future land use map, just showing the future land use map designation overlay. Here is a street view screenshot showing the frontage on Taft Street and street view frontage on Down Street. So this is the rear of the lot. That is the existing garage and the approximate location where the new garage is proposed to be constructed. Here is a screen grab of the site plan, just depicting the lot. And here is another screenshot from the site plan depicting the proposed attached garage with porch on top there. So the applicant has requested specific relief from the zoning ordinance in their application, namely 17.20.120 schedule of intensity regulations. The application is sought for the construction of an attached garage featuring a rooftop deck and entryway into the home through the basement where a detached garage currently stands. The pre-existing garage is currently located within the front and side yard setbacks, and the proposed garage does not further encroach on the public right-of-way or the adjacent parcel any more than the existing garage. The subject parcel and its neighboring parcels were platted and developed prior to the existence of the zoning code. The nature of this pre-existing nonconformity is the primary trigger for the requested relief from the zoning code. The proposed garage is similar in size to the existing garage and is only slightly larger in width and length, only further extending towards the side and center of the lot. The exception to this is the addition of a rooftop porch, for which planning staff have no concerns. The neighboring homes located on Taft Street are of the same size, dimension, and character of the subject parcel, most of which are substandard lots of record, contain detached garages, attached garages, or other on-site amenities such as pools and patio areas within the front yard setback. Staff finds that there are no inconsistencies between the proposal as submitted and the comprehensive plan. Staff finds the proposal to be consistent with the following policies and goals and/or actions as outlined in the comprehensive plan. Housing policy 5.1, review zoning for existing residential neighborhoods to ensure the zoning matches as closely as possible the dimensions and unit types of what has already been built. And land use policy 9.1, protect and stabilize existing residential neighborhoods by making zoning conform to existing uses. Staff finds that the proposal is consistent with the general character of the surrounding neighborhood in the following ways. Nearly all the parcels on the same block of the subject parcel are substandard lots found to be pre-existing and non-conforming, more than half of which have accessory structures by one or more of the following standards as outlined in section 30-17.20.120 of the zoning ordinance. Minimum lot area, minimum lot width and frontage, minimum setback requirements, and maximum lot coverage. So all that's to say is the proposal as it stands is quite not so dissimilar to what it currently exists on the subject parcel and the surrounding parcels. In accordance with Rhode Island general law, staff finds this application consistent with the goals and purposes of the comprehensive plan and is compatible with the general character of the surrounding neighborhood. Staff therefore recommends that the City Plan Commission adopt the findings of fact documented above and forward a positive recommendation on the application to the Zoning Board of Review.
Thank you, Mr. Gurton. The chair notes that neither the applicant nor any interested parties are physically present this evening, but we will go to the online public and ask if anyone wishes to be heard on this matter.
There is no public comment.
Okay, thank you. So noted. Any questions? I'll accept a motion. Commissioner Barbieri moves to accept staff recommendation, seconded by Commissioner Exter. All in favor, please say aye. Opposed, nay. And the motion passes. Next item, 101 Comstock 24 LLC and John B. Canning have filed an application to operate a motor vehicle repair and service establishment at 101 Comstock Parkway.
Evening, members of. Good evening, members of the commission. This is an application from the zoning board for a special use permit, particularly under 17.92.020 regarding uses by special permit. This is currently located over at Comstock Parkway near Western Industrial Park at 101 Comstock Parkway, specifically Suite 24. Kind of giving an overview aerial of it. This is also the future land use. It is the current zoning, which is M2, general industry. And the parcel aerial overview, the red pin is the condominium space. For those of you, this is just before North American on the left-hand side of Comstock Parkway as you're heading up towards Route 12 there. So this here is actually a 26 unit commercial condos that were done roughly in, let's say, the late 1990s or early 2000s. So here's a future land use map. It's all zoned as overall industrial. This goes all the way through Amflex, Western Industrial Park East, goes up down through Stamp Farm, and I believe goes out to the western edge of Stamp Farm Drive and Starline Drive. These are 3D aerials. The open garage bay on the lower left-hand side, third one in, is in fact the site. And some of these photos are done by Street View and by photos from the applicants. We're just kind of going through. As you can see, this is a long-standing existing industrial commercial condo area. This is the site plan. Again, the hashed area indicates the condo space in particular is the third one in from the end. This is unit 24. And again, this is a request for a special use permit for a motor vehicle repair facility. I believe there are two others. One is in the space, I believe, next door in unit 25 or 26. This is also various other, there's a scrap metal plate, like a metal kind of detailing type of place in there right now. So this is in fact it's a use by special permit in the M2 zone. So it's just a request for a special permit. It's an existing established industrial park, and it's been surrounded by heavy commercial and industrial uses. You know, you've got Starline Drive, Amflex. You've pretty much got everything in that whole area. Is the Western Industrial Park that was platted out, I believe, in the late 70s or early 80s. This is in fact listed as use by special permit, therefore they are requesting a special use permit. It's a special use permit in M1 and M2, and there's two definitions as motor vehicle repair establishment light, motor vehicle repair establishment heavy, the difference being the gross tonnage of the vehicles. This is proposed for a light, and the only difference between the light and the heavy designation is the gross tonnage of the vehicles being serviced. Given the site plan and the condo documents that I've seen, these are about 1,250 square foot condo spaces each, and they rent them out. They have controlling condominium documents as well. So I'm not going to go through the entire whole thing, but really at the end of it, this is a heavy commercial or very light industrial, depending on what you're repairing. Heavy commercial or light industrial use being proposed in a long-standing existing industrial park, surrounded by similar uses in all directions for about 500 feet in each direction. This was designed to be commercial condominiums to be rented out for these sorts of things. Future land use map, M1 and M2 are for industrial. These are in fact designed to be for industrial uses. Smaller spaces for people that may not necessarily need a larger shop of their own or can't afford it, but provide the spaces for them to do it, and they can rent them out as needed. So you kind of have not a flow of tenants, but you have a decent turnover with utilities and everything that's on there. So part of the comp plan talks about making sure there's sufficient land properly zoned and adequate infrastructure for that. As mentioned, this is in the Western Industrial Park that was platted out. This was designed to be heavy commercial and industrial. This is what this was designed for. Economic development, kind of looking down the bottom, strengthen standards for industrial zone to prevent not only commercial encroachment into these industrial areas, but also making sure that you have adequate infrastructure in place so that you don't have that creep into it. So if you allow compatible uses to go in, you're not then going to have somebody come in requesting a special use variance for something that may be incompatible because of their inability to retain those types of tenants or have these areas properly zoned for it. And on page 26 of the comp plan, it talks about Western Industrial Development. This particular area is called out. Increasing the economic development aspect of this area. Again, kind of going back to the fact this was designed, built, and accommodating for heavy commercial and industrial uses. Also noting just on there's 26 units and there's 82 shared parking spaces. They can use them all. Those are indicated on the site plan. And it's a commercial building. There's a loop around the entire building, one way in, one way out, but it's a total perimeter. You can drive around it. And I'm pretty familiar with this entire area as I pass by it twice a day when I was living there. Given all of that, find it's consistent with the general goals and purposes of the comp plan, as well as directly compatible with everything around it. Staff recommends forwarding a positive recommendation to the zoning board. Thank you.
Thank you very much. Any questions, comments from members of the commission? Okay, the chair notes that neither the applicant nor any interested parties are physically present. And let me ask Mr. Lima if there are any people online who wish to be heard on this matter.
I see no public comment.
It is noted that there is no public comment. I'll accept a motion. Motion made by Commissioner Barberi to accept staff recommendation. Yep. And seconded by Commissioner Lanfear. All in favor, please say aye. Opposed, nay. The ayes have it. Motion passes. And our final recommendation to the Zoning Board of Review is James A. Baca and Christina K. Baca, trustees, and James A. Baca, applicant, seeking a variance to allow a garage addition to be constructed within a front setback on a corner lot at 70 Ellen Lane.
Now the garage. As was previously stated, the subject parcel is at 70 Ellen Lane, and this is a dimensional variance request. The zone is A20, residential, single-family lots of 20,000 square feet. The future land use map designation is single-family residential, 3.63 to 1 unit per acre. And summary is to allow the construction of a new attached two-car garage and to allow for the conversion of the existing garage into additional living space within the front lot setback in an A20 zoned parcel. So here's just an aerial with a zoning overlay. A20 zone, as was previously stated, all the surrounding homes are also A20. Here's just an aerial view of the subject parcel, again, with the image on the left being a little bit of a zoomed in aerial photo. As you can imagine, the garage is located right in back of where you see the car depicted on the parcel. Future land use map overlay. The entire area has the same designation. Here's a street view with frontage on Ellen Lane. You can see the garage just in back of the tree, sort of in the center right of the image. Street view frontage on Vincent Way. Here are a couple of photos provided by the applicant, current conditions on the property. You can clearly see the garage on the right of the image. Another photo where you can clearly see the side of the garage in which the addition would be constructed. Here's the existing floor plan provided by the applicant and the proposed floor plan and rendering showing what the actual additional garage space would look like. So the application is sought for the construction of an attached two-car garage, which extends 7 feet into the front yard setback, where the subject parcel fronts on Ellen Lane. A 30-foot front yard setback is the minimum requirement for a front yard setback. The applicant's proposal would yield a 23-foot front yard setback. Total lot coverage will be increased from 9.5% to 13%, still remaining under the maximum lot coverage permitted in the A20 zone, which is 20%. The proposed additional living space does not yield any additional dwelling units. The proposed garage does not appear to have the potential to create any new hazards or nuisances which could hinder the quality of life for or safety of the neighboring residents. And planning staff have no outstanding concerns regarding this request for relief from the zoning ordinance. As such, our findings are that there are no inconsistencies between the proposal as submitted and the comprehensive plan. Staff finds the proposals to be generally consistent with the policies, goals, and actions outlined in the comp plan. The policies, goals, and actions outlined in the comp plan do not specifically address minor additions of accessory structures to parcels such as the one being proposed or the specific relief which is being sought by the applicant. Staff finds that the proposal is consistent with the general character of the surrounding neighborhood in the following ways. The proposed garage does not appear to have the potential to create any new hazards or nuisances which would hinder the quality of life for or safety of neighboring residents. As such, staff recommendation is in accordance with Rhode Island general law. Staff finds the application is consistent with the goals and policies of the comprehensive plan and is compatible with the general character of the surrounding neighborhood. Staff therefore recommends that the City Plan Commission adopt the findings of fact documented above and forward a positive recommendation on the application to the Zoning Board of Review.
Thank you, Mr. Gordon. Questions, comments, members of the commission? Commissioner Frias.
One quick question. It says here that the proposed additional living space does not yield any additional dwelling units. How do you know that? Is that in the application or did you talk to the applicant?
Just based on the floor plan, didn't seem to appear to be any like accessory dwelling units or in-laws or anything like that. It was just additional living space.
Okay, thank you.
Okay, for the record, the chair notes that the applicant is not present, nor is anyone present who would be an interested party. Let's go to our online audience to see if anyone would like to be heard on this matter.
There is no public comment.
There is, the chair notes there is no public comment on this matter. Okay, if there's no further discussion, I'll accept motion. Commissioner Barberi moves a positive recommendation to the Zoning Board of Review. Seconded by Commissioner Mancini. All in favor, please say aye. Opposed, nay. The ayes have it. The motion passes. And next item, unless anyone wanted to take just a 2 or 3 minute break. It's about the time we normally do that, but okay, why don't we just take about a 2-minute break? The next order of business is a workshop on ordinances. 2023 state law that changes, has changes that are generally related to zoning. And they require local zoning code amendments.
You ready to go, Ken? So Ken's going to kind of run the slideshow and run the show. And then if you guys have any questions as we go along, just ask me. You got to hold the button, Ken.
Well, I was hoping the paperweight could solve it, from having to hold this for the
No.
next 20 minutes, but. All right. So this is just there's just a couple slides on here that go over the very brief, kind of a bird's eye view, and then we'll pull up the actual, what I like to call the red line language of what this legislation, which is mandated through the state, to have us go through.
And
A little closer, Ken, with the
Yeah,
mic, so.
a little closer on the mic, and I said I wouldn't interrupt, but I will interrupt right here is the zoning things are actually the easy part. The hard part's going to be the subdivisions, which are going to be more applicable to you guys. However, there is a thing called development plan review, unified development, for which you guys will become the zoning board, almost like as a comp permit. We don't have comp permits here because we comply, but so planning board will be making zoning determinations in the future on certain type of developments.
All right. So there were about 8 bills that we had that make some very significant, both procedural and substantive changes to pretty much how we do land development subdivision review. So we have these amendments that we're doing here are required in order for our zoning ordinance to be consistent with state law. So we do have this as kind of the first part of it. The second part of it is amending the actual implementing rules and regs. So if you think of your zoning ordinance as kind of, it enables us to do stuff. The subdivision regulations are kind of the implementing components of how we make that a reality. And so most of the state legislation is in effect as of January 1st. There's one of them that's for March 1st, and the other was upon passage, which is kind of a procedural thing about notices, but we already did. So this is just kind of going over a very broad overview of it. So we have some of the language changes, how we deal with substandard lots of record and lot mergers. They have established a separate land use court within Superior Court, which will deal with the aspects of appeals, in the sense that most of the appeals, for probably 8 or 9 out of 10 cases, the plating board of review, which is the zoning board members that sit to hear appeals from the plan commission here or decisions, they go directly to Superior Court now. And so to set up that, to handle the load for that, they've created a separate land use court.
Yeah, so there's not a separate court like there is in Massachusetts. It's actually a land court in Massachusetts. It would be a separate calendar. Well, that's what the law says right now. There isn't a separate calendar, but that's what the Superior Court will do at some point. Like the gun court, there'll be a specific judge or 2 judges assigned to land use.
So then also the large one was 6061, which deals with a lot of everything that we deal with. It changes thresholds in terms of what's major versus minor, in terms of subdivision, defines land development projects, all that sort. And it also kind of clarifies adaptive reuse and adds that to several different things. Let me minimize this really quick. So I kind of put together a kind of a broad, there's a lot of interconnected pieces with all this legislation. There's a couple, 2 or 3 pieces that kind of touch upon different areas all at the same time. So I kind of did a very rough area of what section of the legislation changes what portion of the zoning ordinance, and I put them in order and kind of by the numbers through the zoning ordinance, so we could go through them as that. All right, so so a lot of the language and it deals with appeals, as we've mentioned. We're still kind of looking at this one and figuring out if whether or not some of the language, it's unclear as to whether or not the formal procedure where, as we've said, people that wish to appeal decisions from the commission would go to the plating board of review. It's unclear through the legislation. There's a couple of areas that are unclear in this legislation as to what their intent was. And it seems as if for almost all cases, the plating board of review goes away and your appeals go directly from the plan commission directly to Superior Court, cutting out the first level of local appeals. So this is actually a section in the city charter dealing with provisions regarding the plan commission. We've redlined it for the time being just to show essentially what the new appeals language would be, but we're kind of getting some more clarification on whether or not that needs to go.
Could I ask a quick question? on that? So it's more of a comment really. On the charter, that's going to require voter approval for it to go into effect. So you have plenty of time because we're not going to put anything on the ballot till November and it'd be a passive resolution council. And just on a general note too, I understand that we're complying with state law here. I don't really have a strong feeling about keeping the planning board anyway in our charter, but I would just be cautious about how you phrase that. Because we don't want to eliminate the plating board in its entirety if it actually still has a function in certain instances. That's my 2 cents, because, you know,
And I think that was part of the reading. It's ambiguous as to whether or not they had intended it to be eliminated entirely because it seemed like the way it was, but then there are certain sections in the actual legislation, which was that 148-page document, where it indicates it still exists, except for certain circumstances where it just goes directly to Superior Court, and that was kind of the ambiguity. At the end of the day, I think it was one of those where we can leave it in, and if we actually believe that there's gonna be some pushback on when people realize what that actually is, but wait, there's no plating boards. I think it's one of those, we just have it on here as something that might have to be revisited later, and there's no sense, especially because it's a ballot question, charter change. There's no point in doing something if maybe later on something else gets changed and it comes back or there's clarification but it was just listed something we wanted to show as part of that. This is how these things change. So I think I have it now here where it actually works. So on here, these are definitions. What they did was in terms of adaptive reuse, and I believe adaptive reuse was 6090 sub A, and it essentially adds in, refers back to the definition for adaptive reuse. And if I remember correctly, this definition, that definition's under, I believe it's the tax stabilization legislation that allows municipalities to get into TSAs. And so they referred directly back to that definition as part of this. The only other part of the definitions that changes is down in variances. This is just showing that they've eliminated a larger definition of what a variance is. It was something that we had copied over from state law, and this is just clarifying that state law has eliminated this piece, and it's just making a cleaner reference to another state law provision, which we'll get into shortly. So another major component of this is that special use permits, much like our motor vehicle repair establishment, light and heavy, there's a new requirement that says if you have something listed as a use by special permit, you have to have specific and objective criteria for that particular special use. So we do have sections in the ordinance dealing with, I believe, gasoline fuel station, gasoline service stations, telecommunication towers and antenna, I believe mobile home parks, hazardous waste facilities. I want to say there's 1 or 2 other specific sections that deal with particular uses that you have additional findings that you have to make relative to those particular types of uses, special uses. And essentially what they said was anywhere in your ordinance that has a use that you have it's a use by special permit, either you come up with specific and objective criteria for that specific use, or eliminate it entirely in terms of either make it by right or prohibited. So for instance, the one that we could see on here, tourist home bed and breakfast, it was a use by special permit in the A80. If you wish to maintain it as a use by special permit, you would have to come up with special additional findings for tourist home bed and breakfasts anywhere you have them. Even if it's in one zone, you would have to come up with an entire new section that deals with tourist homes, bed and breakfasts, and additional findings that would have to be made to keep it as a use by special permit. Same thing with, for instance, cemeteries. You have to come up with specific and objective criteria for cemeteries, in addition to the special use permit findings that you have to make for any other ones. So what we did on here was we went through and looked at certain special uses that we don't already have, those 5, I believe, that I mentioned off. They going through and finding that uses that were used by special permit, and we had to make kind of what works, what makes the most amount of sense and make them either prohibited as in no, or permitted with a Y. Many of them, we did in fact go and make them prohibited because we don't have the, you know, certain things like, well, do we need to have certain findings for these, or what, did it make any sense to have these as uses by special permit if there was any particular reason? One of them I do want to bring up to you is an upholstery shop. The other way? Oh, upholstering shop. For whatever reason, it was a special permit in, I believe, C4 and C5 or C5 and M1. We didn't really know why that was to be the case. So he said clearly an upholstery shop, if anybody's actually still doing that anymore, you would have to have come up with special, specific and objective criteria in addition to your special use findings that are already promulgated under state law that we currently have. You have to come up with specific and objective criteria for an upholstering shop. So we had to kind of make decisions as to what made sense. And I think we kind of took a more conservative approach of, we could look at it later and say, oh, perhaps we can come up with things later. You know, I think self-storage was something like, issues of parking and self-storage where you don't actually need as much parking. You know, there's certain things that we thought of, well, we can look at that in the future, but for the purposes of the legislation that's coming up January 1st, we had to make some of these changes. The other portion of this down at the bottom was where the the zoning official, if a use is not specifically listed, and this particular one is one of the areas I had concerns with in terms of language, and you'll see why. Where it says any use that's not specifically listed, the zoning official has the ability to compare the proposed use relative to another similar use that's already in the ordinance. And if he finds that it's similar enough to that use, it becomes a use by special permit. Well, if it becomes a use by special permit, does that then become, if we don't have specific criteria, specific and objective criteria, why does it become a use by special permit? So that's part of the requirement under the state law, is that the zoning official has the ability to say, whereas now if it's not listed, you're out of luck. Now it's, well, if it's not listed, you can compare it. And if it's close enough, essentially, you can make it a use by special permit, which then goes back to my initial concern of specific and objective criteria, which is that language.
Just, there's, last year they passed an accessory dwelling unit law. And once it got into practice, and all the cities and towns started to use it, they realized there was like 17 things wrong with it. And we tried to fix it and they didn't fix it. There's going to be, I'm sure there's going to be unintended, matter of fact, I know there is already unintended consequences to some of these new laws. So we're going to implement them as instructed. And then I'm assuming, they'll be amended later on next legislative session or 2 years from now.
Quick question on the special permit. We don't need to go right now. I want you to, finish your presentation because there's a lot of changes on special use permit. But a special use permit, the concept behind it is this use, whether it's kennels, nurseries, whatever it is, it could be allowed in that area right now, but it has to get permission from us from looking at the comprehensive plan. So the reason behind it, I assume that it's a special use permit, is the idea that there could be situations where people would not want that particular type of use in that zone, right?
Yes, that's correct.
Okay. And so you made a determination with the staff, made a determination that these special uses should be allowed by right and others should not. When it's allowed by right, obviously, it's much more challenging legally to eventually decide not to allow it, because you'd have to look at the comprehensive plan to see if it's consistent or not with that. The ones that do have an S right now still, and I want to be clear about those. There are standards that are specific and objective in our code. You review that, like the community antenna, the solar. Also, I saw like adult nightclub stuff. So there is exact specific and objective criteria. You think that passes muster to allow special use permit for that?
I would say that it does, yes, because the uses that we had left in there were uses that we already have additional criteria, whether they fall under specific and objective to the state's level. I would assume that they do because we haven't had an appeal of that as far as I know. But also to your point, one of the components of these special use and variance legislative changes was that all of the new specific and objective criteria, you can come up with that criteria, whatever you see as fit, but they specifically said, and they specifically prohibited, one of those criteria cannot be a finding of consistency with the comprehensive plan.
Right.
In addition, on that same legislation, as kind of the carrot over on this side, they eliminated the finding of for a variance because they put these under the same legislation. They eliminated the provision of least relief necessary and no financial gain in terms of a variance. So I've always, one of my other municipalities I worked at, we had I used to say, if we don't grant use variances so they can realize greater financial gain, we shouldn't be granting variances or waivers in order to reduce financial responsibility. So they eliminated the financial gain and the least relief necessary provisions of findings for variances. And that was included in this legislation, which literally as a line item veto, you wouldn't have noticed it unless it was printed in color. So this section here dealing with conformance to district regulations, the easiest way I can call it is think of a sliding scale in terms of your setbacks. So we all know and love our setback table that discusses, okay, you're in this certain zone, you have this certain minimum frontage area, setbacks, maximum lot coverage, building coverage, et cetera, so forth and so on. What they're saying is that if you have a substandard lot of record, so a lot that was prior to existence, and I believe it's January 1st, 1966, it's an existing platted lot, you can turn around and file for a building permit, and looking at the requirements into your dimensional requirements, frontage, setback, coverage, et cetera. So say, for instance, you have a 2,000 square foot lot and it has, let's just say for the sake of argument, 100 feet of frontage. If you have 1,000 square foot lot, your frontage decreases by 50%. So everything is proportional. We've actually created a calculator, just an Excel spreadsheet really, where you can, we can punch in the area of a lot and it calculates your frontage. There is the theory is that this would be used by, say, the building and zoning department in order to confirm the setbacks and whatnot that are being shown relative to the substandardness of the lot, so to speak. So that is for existing substandard lots of record. So we also have a provision called modification by the building official. This has been something that we already have. And what it says is that I believe modification was done in order to reduce the amount of cases going in front of the zoning board for innocuous dimensional relief requests. So modification, which is what we currently have this now, and actually the standard that the state has now set as a requirement was what we had all along. So this is something that we have now, but we're just codifying the changes. But in practice, there's really not much change when it comes to this. It just clarifies there are certain thresholds and notices. But essentially a modification by the building official says is that if somebody comes in for a building permit and they're within a certain percentage of the requirement, 10% goes up to 25%. If you're within that amount, the building official can say, okay, hold on a second. I'm going to send a letter to all the direct abutters just by regular mail. You have a certain amount of time. You can come in and take a look at it. If anybody objects to it, straight to the zoning board. If nobody objects to it, they can issue the building permit then and there and just note that this was done by modification by the building official. Again, we have this now. I witnessed it when I was working in the building department. It actually works great because it's, for some of those like functional, you're within literally, 3 or 4 feet of something. Pretty wide amount of leverage and leeway that they allow the building official to consider. So again, we have this now. It's just we're just making the language consistent with what state law says. The real substantive change, so to speak, is that anything under 5% can be granted automatically with no notice to the abutters. Anything over 5 and less than, I believe it is 25, they still have to give the notice. So that hasn't changed. It's just that they've added a provision that says if it's less than 5%, you can just issue it. So for that instant, the building official is taking a portion of the powers of the zoning board. But again, they've already done that. It's just that it's eliminating a butter notice, direct abutters only, for something that's less than 5%. Now think about your standard setback. Take 5% of that. If you're within that from the setback, state law says that they didn't feel that that was necessary to make, applicants go in front of the zoning board for relief amounting to less than 5% of a requirement.
And they shrunk the time frame from 30 to 14 days to, if you're a homeowner and you want to object.
A question about that. I know on some of our other, where we give notice, we say within so many feet and we have so many days and we could make it more liberal than what the state law required. Is that the case with this, the 14 days, or are we compelled to make it 14?
They changed it from 30 to 14. So we make it greater?
Do you know what I'm?
Yeah, no, so we can,
Is 14 the maximum or 14 the minimum?
check on that.
I think it's, I don't have it in front of me, but I think it's the maximum.
Maximum.
I don't have it
Yeah,
in front of me,
no,
but
then, correct. Because they wanted to shrink it. Yeah, no.
Yeah, I think that's typically how they interpret those sorts
Which
of
is on
things.
14 days from when they receive it by postal or from when it's mailed out.
So that would probably, under mailbox rule, that would probably be step. Mailbox rule, usually they assume 3.
How they come up with this, I don't know, but I wonder statistically, how many people actually object? Like, if Stan sends out 100 of these, how many people, does he get one? Does he get, 100 different parcels of land? So I don't know, why, obviously they shrunk it to make it more streamlined, but I don't know how practically it impacts the zoning office, because we don't see too many from Stan saying, oh, it was a small modification, but it's here because someone objected. Yeah. Unlike in Narragansett, here we only did the required changes. Some towns are doing optional, some towns are, doing optional changes, but we only did the required changes, so that way the city council will, they don't have to adopt this, but if they don't, we'll have a code that's out of compliance with state law.
I apologize. It wasn't direct abutters. It remains as the 400 feet under section, what's the new section C? But it remains as the 400 square feet. I thought it was direct abutters, my apologies. So I'm not sure if I'm sure some of I know some of my colleagues do, and I believe the chair knows, I've also, being from Rhode Island, I've also worked in Massachusetts. And so we have this concept of special permit granting authorities. Just don't ask, Peter LaPola, because we'll go into a reminiscent story from Braintree as I do, but this concept here, this is an entirely new chapter. This is gonna take, this is the in between development plan review and I believe special flood hazard overlay. So unified development is currently something that, as of right now, because this goes into effect January 1st, unified development allows the planning board of the city plan commission to act as the permitting authority, essentially to act as the zoning board when somebody comes in with a subdivision or land development project that also requires some sort of zoning relief. So this, as of right now, this is, you may use it if you want to, but you don't have to. January 1st, we shall be using it. And I believe Warren, Providence, and I want to say Johnston are the only three that a brief look at. They're the only three that I believe that currently use Unified Development Review. But essentially it acts similar to how special permit granting authorities in Massachusetts work, whereas somebody comes in with, say, a subdivision or a land development project that requires relief from, say, setbacks or frontage or something like that, some sort of zoning relief, the plan commission will have the ability to essentially make the same findings that the zoning board has to make for dimensional variances, use variances, special permits, etc. So really 3 findings would be made. Let's say somebody's coming in for a special use variance and a land development project. You'll make the same findings under a special use permit. Let's say that it's a, communications tower, right? So you'll make findings that are under the special use findings that we have for everybody that you have to find. Then you have the telecommunications special findings. If there's a variance required, you make the variance findings, then you make the land development project findings under the state law that we do for subdivisions as you do now.
Ken, we're gonna have to look at this. I just noticed. So on unified development, 1786-030A. So Jason, right now, our radius is 100 for a subdivision. And it's 400 for zoning. So this has 200. So I think we need to increase it to 400 because that means if you needed a zoning variance under unified development, it would be a smaller radius than a normal one. So I think, 1786-030A, middle of the thing should be 400. You don't have to do it right now, but we should change it for our final draft. I just noticed that.
Yeah, because that was what we used to have that requirement as well, where you would have, if you had 2, you would have to do the most amount of abutters just for the aspect of it. So now this comes back to our substandard lots of record and lot mergers. So this is kind of the piece that deals with existing lots. So what they're saying now is if you have an existing lot of record under the new legislation, if you have an existing lot, typically as it is now, if they're under a certain size, they're merged automatically. It's called the merger. We usually have the merger clause or merger doctrine. Most, I believe all 39 municipalities have it. Mergers are automatic based on certain factors. The new requirement now says if the substandard lot, it could be either an empty lot, you get a house that has 2 lots, the side yard is an extra one. That lot is not merged if that lot meets, I believe it is, and this was the language that they had, if it's an area equal or greater than or equal to 50% of the surrounding lot within, I believe it was like a 200 200-foot abut radius of the lot in question as confirmed by the zoning officer. So what that pretty much says is that you have a substandard lot and you want to say, it's not merged for the purposes of zoning. You have to provide proof. You do your 200-foot radius, you take all the, you take the, the average of those, of the lots in that, the area, and those lots 200 feet around you in all directions. And if you're less than or equal to the average of that, that is not a merged lot anymore. It stays a separate lot. And then you can then turn around the bottom piece there under section C. It says where 2 or more lots are combined in accordance with this section. Eliminate the rest of it and say they may be regulated in accordance with the conformance to district regulations, which is that sliding scale that I had talked about in terms of the setback. So what it says is this one says if it's not a merged lot if it meets this threshold. If it crosses that threshold, you're then subject to the sliding scale in terms of a building permit for in terms of a structure on that property. So that opens, there's our lots unmerged now automatically. Does somebody petition for this to get it memorialized? That's part of the, procedural questions that we kind of have with this. So back to variances, when I had talked about the fact that they turned around and eliminated the required findings of least relief necessary and greater financial gain. So these findings are what you as the commission would be finding under Unified Development Review if somebody came in for a land development project or subdivision, right? Somebody comes in and they're requesting relief. These are the findings, 17.92.010, B 1 through 3 now, because you've eliminated the relief as the least relief necessary. The perfect example of that is somebody, again, past that I've dealt with. Somebody comes in requesting a subdivision for 2 triple deckers on the same lot, and they want to put a line down the middle of it, create 2 lots that are substandard in just about every way possible. And because this person had gone on record and said they did not want to, they wanted to get the subdivision because by doing so, 2 separate lots, 3 units apiece rather than 6. It's a residential mortgage rather than commercial mortgage, and they didn't want to do that. So the argument that was made was that, well, the relief could be you just condo it. You never come in front of us. It's a form of ownership. It's not use. But the least relief necessary is you don't need to come in front of us and request all these waivers. You can just go this other option and you never have to see, we will never see it. We would never know of it. So these are the findings that changed. Again, this is what state law said. They determined, well, the hardship isn't the result of any prior action of the applicant, period. Whether you get some sort of financial gain out of it is no longer relevant come January 1st. When I had mentioned in the earlier section on definitions, this was the piece that we said, this section goes back and talks about when we have dimensional variance in our definitions, this is the piece that they refer back to in the state law. This is the change that goes back to it. So it's what it says is that relief is sought minimal enjoyment of the property. This kind of changes some of the findings that we would do. And we just clarify in here that the zoning board or the plan commission under Unified Development Review is allowed to use these as their findings. And again, this is the question I have is a use by special permit, but if the building official finds that it's close enough to something else, it's a use by special permit. But if we don't have it, what are your actual specific and objective criteria? That's one of the main questions I have about it. Public hearings, this is just something that we do now in terms of posting public hearings in areas, making them available on the webpage. We do that now, but they're memorializing it in state law. Quorum. Quorum, I believe this was a one from the previous legislation, or yeah. And that is everything. This is just, this isn't anything that, I don't believe that there's no vote for this. It's mostly just saying, here is the, you know, here's what the state law is saying that needs to get done. And we're just showing
Yeah,
the changes that would be made.
and there will be a vote later on. You'll be able to weigh in later because it's gonna go to the council and they're gonna have to send it back to us anyway. So this is just a right, wet your whistle kind of, just see what's coming. So yeah, hopefully it'll come back. Hopefully it should come back in November, we hope.
Yeah, it'll be the standard amendment process for any zoning ordinance amendments. This will get submitted to the council, comes back to the commission as, the required the report and recommendations and so forth.
Right, Mr. Chairman, this would get sent to the council for adoption as new business. I don't believe there would be enough time to advertise that November meeting with us for the formal vote. So November could be an additional workshop if we wanted to on this, but this would be a December vote for this.
Yes, Commissioner Lanfear.
Thank you. I just wanted to raise one issue for, I guess, staff and all of us to think about, because there's never an opportunity to sit with fellow commissioners and talk about something without running afoul of open meetings unless we do it while we're at a meeting. So if you just bear with me for a moment. I did have some concerns on the use tables, and my concern is, and I understand why we're doing it, and I appreciate that staff went through and tried to make some choices with regard to whether or not some uses became yeses or nos. But the nature of a special use permit means that someone before us along the way, the council and a planning commission, determined that that particular type of activity, while it might be the right use somewhere, there were some things about it, some qualities about that use that required another look and a different standard. And my concern is that for anything that we do not have criteria for, specific and objective criteria, we shouldn't say yes to. We should say no, because that would be the least harmful to the city and the residents right now. It doesn't preclude us down the road from turning that no into a special use permit with certain conditions and specific and objectives. But if we say yes to things that by not having specific and general criteria, we're just saying okay to every type of that particular activity that used to require a second look. So I think the better approach is to be more conservative and to say no for now on our use table. And then we can either by a subcommittee or some other way with staff go through those one at a time to ensure that we have either appropriate, specific and objective criteria, or maybe we'll decide that some of those can be a yes. But I think it's best to do it in a reflective way where we all participate in that, because ultimately it would go to the council as well.
Thank you. Commissioner Frias.
Yeah, I just want to echo Commissioner Lanfear's comments to some, when I read, this legislation passed in 6059, the Rhode Island Planners Association brought up this problem about if you can't use the comp plan to deny a special use permit unless there's specific and objective criteria, what could happen? And they said it may result in communities temporarily prohibiting certain uses rather than risk a by right status. And I think what Commissioner Lanfear is saying, and I understand it and I tend to lean towards it, is unless we know for sure at this point, this should be by right. And we should by default err on the side of not by right. And then come up with either specific criteria or just for a special use permit. I'll give you just I went through this and I don't want to make people sit here for like a half hour going through each one of these things. But when this comes to a meeting in December and you want my recommendation, I'm going to do that if there's a yes. And I'll give you a couple examples. They're just pretty simple, like a kennel in A80. Does a kennel sound like a problem in A80? No, not most of the time, but if that kennel's within a couple of 100 feet of a subdivision in A80 like Ridgewood, I know a lot of neighbors are not going to want to have a kennel with a whole bunch of dogs doing that. We had a case here maybe a year ago where this issue came up about, whether or not the kennel, somebody didn't want a kennel to be used because it was going to be potentially close to a proposed subdivision. Okay. Here's another one. Extractive industries. Extractive industries is allowed now by right in an M2. Extractive industries, includes oil and gas drilling, which I know is unlikely to occur here, but it also includes blasting for a quarry. Some of our residences are actually kind of close to some M2s. So if you allow blasting by right, and these residences are pretty close, it could be a problem. Then we have this thing, outdoor advertising billboards. I know we denied those completely, which I understand, fine. We want to err on the side of caution. But we're denying those completely, but we're allowing yeses on a whole bunch of others. And see, I'm not really threatened by advertising billboards in industrial zones. I ignore signs when I drive, unless they're traffic signs or it's a bathroom sign, that's about it. And so that's where I looked at it, and it's basically kind of split it where it was like maybe there's like maybe let's say 90 or 100 of these special use permits in different zones. And you kind of split them half and half. Half went to yes, half went to no. And so for me, before I make a recommendation to the council saying thumbs up, you're going to need to walk me through every single one of those yeses and explain why that should be a by right there, because it's not a by right now. And there's usually a reason why it was not by right, because of these exact issues I'm talking about. They may be too close to a residence. There may be some other issue. So I want you to think about that, because as Commissioner Lanfear says, the simplest thing is a no. And if somebody wants to come in and propose that, well, they could make a zone change. They can make a proposal to do specific and objective criteria as a zone change, and we can review it. But when you allow a yes, then I'm left with the situation of a by right where then I got to go through the comp plan to see if there is something here that potentially is inconsistent with it and may lead to litigation. So that's my comment to the staff. I leave it to you because I know it's your staff, it's your work product. In the end, it's going to come before us in the council. And do you want to talk about, extractive industries within, right next to like residential properties?
So I think just not to do much back and forth, I think we did want to take that approach of saying, are there certain things that, like a upholstering shop, for whatever reason, why that was included as a special use in the two industrial zones or C5 and M1. We don't know. I don't believe anybody who would even consider that is even around anymore in terms of on this earth and here on the commission. We did want to take that approach of saying there are certain ones that we already have. I believe extractive industries for quarries. I do believe that is the other. I believe that's number 4 or 5 in terms of the ones that we do have extra additional criteria for. I believe that's the case. I'll check a look into that if we don't already, but I do believe there's a section in the ordinance that deals with quarries and topsoil removal. Aside from that, quarrying and mining operations, I believe. So I believe there are ones for that. And then also too, I think some of it was the things that made sense. We would say yes, because also don't forget with development plan review, you catch any non-residential use. So it may be uses that are in non-residential districts, but also non-residential uses in residential districts. So I think part of it was some things clearly, no. It was, well, to make it easier, and also it makes sense with the time frame of which we have to work with this, make it no, we can come back to it later because there are certain ones that we do want to look at when we have more time to delve into those particulars. In some of them, we said, if we say yes, we could catch it under development plan review again, because of those, as we had heard earlier, things, the exemptions and what's applicable for DPR. We felt that with some of the ones that we did say yes for, we would be able to catch that under DPR, or if the commission felt it was better to, go with a more conservative approach and say just no to everything, we'll come back to it later for everything. That was an option too, but we did want to keep it so that the things that were clearly no, or the things we didn't feel comfortable with because we don't have the time to come up with those standards just yet, and we'd rather not rush through and come up with a set of standards that may not match, we can always come back to it later. That's the great thing about doing this, is that we can always look at it later. We said for the ones that we do say yes to, we felt comfortable that development plan review would get it for that. But we did take that approach of, if we believe DPR can we can catch it with development plan review, we'll make it yes. For most of the no's, it was not dealing with it. For some of them, it was, we made a note to ourselves of, we're going to come back and look at this later because we do want to have that criteria. But we did realize that there are certain uses that we would want to look at in the future, but with the timing, we wanted to make more of them no, and make certain ones yes. And that will be part of the analysis that we'd be doing, is the ones that are yes, we'd lay out how we feel those fit.
Okay, and I understand if there is a specific standards for the quarry stuff, like you mentioned earlier. You just have it as a yes here, didn't keep it as an S. So that's why I assumed that, if there was specific criteria, you would just leave it as an S rather than go to a Y. And just one other thing on this thing, the things that concern me on it is anytime you did a yes in an A80, because like I said, an A80 has residences. And there's sometimes you did and there's sometimes you didn't. And so that is going to be a concern, because we do have sections in our city that is, as you know, A80 residences. And then you had one on open space, you allowed a yes on alternative energy generation. I think that's the S1, S-1.
Yep, down the bottom right-hand corner, yeah.
Yeah. That's on page 5 of 8, and it's the last one on the bottom. Just ignore the buzzing noises. So, that one, I personally believe open space is open space. So we have an S there, and I don't know all the history that other people may do about what does that mean, what criteria can be used to allow something to go there. But generally, my feeling is, if it's open space, it really should be open space. And I think you may have issues with that potentially, because if I look at all the uses in the S1 that you changed, the only one that went to a Y was that one. So that's why I just wanted to point out to you on that too.
I believe that one we put it as yes, only because there are the additional There is a section on solar, but it goes back to your comment about if we already have those, if we already have those specific and objective, why not keep it as S? I believe I believe that those are listed as that, but perhaps it was just a scrivener's error or something like that. But I do know that there is a particular section that deals with, I don't know if it's titled alternative energy or if it's just like solar or something like that, but I believe that might have been what it was. And we said, well, we have requirements already that they have to meet. Should they go through special use permit, or we already find them with, as part of, I think that'll be something we'll look into as well, just to clarify that.
All set. Okay, we will see this again, obviously, and these have been good questions and concerns brought up to take into consideration as we move forward. Now I'd like to turn to the planning director's report. Thank you.
Thank you, Mr. Chairman. The first thing I wanted to talk about was we had a discussion, or I wanted to have a short discussion on the survey questions that were going to be part of that mapping tool for the comp plan. So I think that I sent it out to everybody. We did get some responses, and it raises a question about the efficiency of getting this process done. Right now, we can't just on the fly make changes if individual members of the commission say, well, I think the question should be X, like let's change them to this. I think that's problematic for us moving forward, because it's not a process that's very orderly, and I think that it causes some problems. I think that some of the questions, I think that we might have had some questions about. These are the survey questions I'm saying. So I think it's just a bigger issue of how we're going to proceed over the next year plus, working on this with members of the commission, and working with the consultant and working with staff, and how do we come to a decision on how do we move forward, because it's unclear about how this is going to work moving forward. So that's kind of what I wanted to talk about on that. I don't think that we're ready to change the questions or come up with new questions at this point, but I'm just concerned about how we're going to handle this moving forward. Staff reached out to statewide planning today, and they basically told us we're the only community in the state who's done the comprehensive planning process without having a comprehensive plan committee. And maybe in my mind I was thinking was it a subcommittee of the plan commission, or is this a larger committee that has the authority to kind of work with staff on this process? But I think it bears discussion that it's not clear right now how we're going to move forward in an efficient manner and work on this process through staff, and not have questions come up that basically put a halt to what we were trying to do with that that survey or any other issue, because it does kind of freeze you, because you can't really move forward because now we don't quite have a process in place. And I think what I'm trying to say is we don't have ground rules and how we're going to to work through this. And it's something that we probably should think about course correcting on, having some type of ground rules. So I don't know, I leave that open to the commission for their comment, but
I've started drafting some possible recommendations to help facilitate openness and promote discussion, and and so forth, but I'm not ready to present them tonight, but
Okay,
we'll circulate those before the next
so,
meeting.
so I think that, you know, we need to come to some kind of understanding because we get to a point where we can't make a decision, we can't move forward, and we're just going to be stuck for a month, and we are on a tight time frame. So I want us to be able to, you know, react and feel confident that what we're doing is the right course of action. But if we feel that there isn't these ground rules, it puts staff in a position where we have to keep bringing things back to the commission for discussion, which is not going to work. Not going to work to get us on our time frame. So we need to discuss this next month. And I wanted to have that as a workshop item about, you know, let's set our ground rules and really come with a process that's going to be efficient. And whether that means we think about having a comprehensive plan committee, or we're going to be working with staff through the consultant, because it's just going to just really slow us down. I can't make, you know, command decisions when we have, you know, individual comments on, you know, decision points, without bringing them back to the committee. And if we had 5 years to work on this process, yeah, we could do that, but we do not. So, that's my concern.
Okay, thank you. And also, you have other things on there, so.
We talk about this?
Oh, absolutely.
Okay.
Absolutely.
So,
Please.
and maybe other commissioners want to talk about. So I'm one of the people, maybe I'm the only one, I don't know. I sent some revisions to the questions and some possible questions to include in the survey. Now, these are just thoughts I had. Now, let me just start out why I did it and why I think our involvement in this process is important. Our involvement, meaning the commissioners. The reason I did it is that I believe that, number one, these questions sometimes presume a certain answer. They presume sometimes things like, let's see. That there's almost like a problem, and that what do you want to do to make this problem better? That could be something about renewable energy, it could be something about housing, it could be something about any other aspect, but it always presumes that there's something we want to change. And I'm not sure that sometimes the people of our city really want certain things to dramatically change. So the questions I sometimes asked was very simple ones. Are you satisfied or dissatisfied with the current situation as this? Are you satisfied or dissatisfied with this situation? And because two things about this, it's basically polling people to some extent. Now, because this is an interactive thing, I know that people are going to self-select and they're going to decide that they want to respond to this. And people who do tend to have very strong opinions. What I'd like is to not gear the questions towards particular responses. I like it to be more neutral worded. Now, I may be in the minority on this commission about that. That's fine. But if anyone knows this about a poll, if you ask a question a certain way, you get a certain kind of answer. And so I don't have a problem with having more neutral questions or more open-ended questions. And maybe some of the questions I asked were not that great, but that was just my thought. In regards to the commission's personal involvement, I was ready tonight to talk about these questions. Totally. We could have talked about it. I would have brought copies. I only brought one. You got to move quickly. I get that. The way of moving quickly is just getting a decision. When you bring it before the body, you talk about it and you work it out. Creating a subcommittee or creating a committee. This is our recommendation to the council and to the mayor. And we will get public comment and we will take that into account. In the end, this is our policy recommendations to them, and then they will get public comment and they will work it out. When you say, hey, we have to be efficient, the way to be efficient is not adding more layers of committees. So when the comment is, well, it's not going to work, I got to make decisions. Look, decisions need to be made, and I get that. But when you're talking about when we do stuff with the public, like this kind of things, I don't see the problem of, hey, commissioners, what are your thoughts on this? Let's report back at the next meeting. We make a decision, we move forward. This could have been decided tonight, one way or another in some ways. So do we have a deadline? Yeah. And I'm willing to work and put the time in to meet that deadline, but I'm not interested in a process where the commissioners themselves are presented with, this is what it is, and we don't have direct input. Because in the end, this is our product. My name has to be on it if I'm going to make a recommendation for it. Your names will all have to be on it. You have to be comfortable with it. And that's why I don't see the harm in just getting our direct input. And I don't see the problem with it as long as we just have a timely way. There's going to be a decision. This is the timeline, file it, give it to me, we'll make a decision and we move forward. And am I going to be like on these questions? Look, I already know what the story is on these questions. People will give their responses. Like I said, it's the people with the strongest opinions rather than sometimes the people who actually are reflective of the whole community. So I'm going to put some limited weight on these responses in general. But this is just an example to me of, in the end, it's up to us as commissioners how much input you want on this. Because of the type of commissioner I am and the responsibility I feel, I've got to have my attempt to at least put my input into it. And if the majority doesn't want it, that's fine. But I got to do my due diligence. I got to try. And I don't think there's anything wrong with us being directly involved in this way. Thanks.
Thank you, Commissioner. Any other questions, comments? Commissioner Lanfear.
I would like to address the survey as well. And I appreciate that that was sent to us. And I also responded. We were given a time frame in which to do that, and I barely, but did make the time frame I was given. Because we can't reply all, I could not exchange with my fellow commissioners what my thoughts were. And similarly, I don't know what your thoughts are, but I respect each of your opinions, and I would like to know that. And I thought that when we were going to have a discussion and a workshop, that's what it would be. You would find out what my comments were. I would find out what your concerns and thoughts were, but that's not how it ends up working out. And I think that's something that we need to change. I agree that we need to be timely, but I also, and I'm going to make available, and I will put one in the record so that it's part of the record, what my response was. What I talked about was the manner in which questions are asked can create answers that are skewed one way or the other. So could we try to make them more neutral? In reviewing topic areas, I'd like to see a topical area that queries about neighborhoods and asks respondents what issues of importance most directly affect their neighborhood in a positive way and a negative way, and how the comprehensive plan should address those issues. I'd also like to ask an open-ended or neutral question about what issues addressed in a comprehensive plan are most important to a respondent and why. Similarly, a query about what issues directly affect the quality of life in Cranston or are the reason they became and continue to be residents of Cranston. Now, that might be only my opinion, and after I hear from fellow commissioners or see what you may have submitted or suggested, those ideas might change. And that's the kind of dynamic I think we need to have for a comprehensive plan among commissioners, because ultimately we are the ones that are voting and recommending. And I would have thought that once we did that and sent our comments in, somehow we find out what each of us has said. The only one who knows is the planning staff. And it's good that you know, so that you can figure out what the commission is concerned about and where we're coming from. But I think the commission has to be informed. I don't think we can all be islands and have our own thoughts and not know what others think. We have to do it in a forum that is consistent with state law and is done publicly. So this is the only way we can do it. And I will share with you what my thoughts were, because I want you to know and I want to share that, and I'll make it part of the record so it's available for public review and complies with open meetings. So Mr. Chairman, I would just encourage, and I know you said you are working on something, some process, and I agree, Jason, that we need to have a process, but that process needs to heavily reflect interaction of commissioners. And so I would look forward to what you're going to suggest, Mr. Chairman, and would be happy to talk to you at a meeting so that we can all sit together and come up with a process that we're all satisfied.
Okay, thank you. Yes. Any other comments about the process so far? Okay. There was, I don't think it was mentioned earlier, but I know we talked about it at the last meeting or the last workshop, was walkthrough on the Costco property. That is now off the calendar. It was the applicant who requested a
The
delay.
applicant has held the application, so we'll, probably December now at this point if they decide to get back on track, but it was at the applicant's request to delay, so. I don't know. I have no idea. It's been a mystery. They were all set to go last week and then just pulled out. So
You may take that off of your calendars for that Saturday morning. That's all I have. The next meeting is scheduled for November 7th. Regular meeting. Same place, same time. Anything else for the good of the commission? Commissioner Frias.
Mr. Chairman, I mean, if the planner wants a decision on some of these questions, we could have a meeting at the end of this month at some point and just have that taken care of. Yeah, I mean, if Costco's not coming, maybe until January or later, we have space at the end of October and in November to get more stuff done. And if the issue is we got efficiency and all this other stuff, hey, let's do something at the end of October, get this banged out and start moving along.
I for one would be fully supportive of that. But we would just need to pick a day.
Is calendars, third Wednesdays, or Tuesdays or whatever it is. And of course, we can see what the city, whether or not the city council is meeting.
The third Wednesday and the third Thursday are open days on the calendar in October.
I'm available, either one.
Wednesday or
Actually,
Thursday?
we have HDC on the Thursday. So Wednesday is the open night, Wednesday, the 18th.
Does that work for everybody?
Does that work? Yes, for everyone? The 18th.
Let's, I'll make a motion then to schedule our next meeting for October 18th
All right.
at 6:30 and to talk about the comp plan and to make decisions about what questions to be asked.
Okay, motion made by Commissioner Frias, seconded by Commissioner Lanfear. All in favor, please say aye.
Aye.
Opposed, nay. Ayes have it. Excellent suggestion. It's a Wednesday, the 18th.
Mr. Chairman, do we want to have legal counsel? And I think Commissioner Matus just said he's not available either on that day.
Yes, correct. I just got a notification that I have something to do that evening.
If the third Wednesday doesn't work, the fourth Wednesday does work, which is the 25th.
Okay. I made the first motion, it didn't work out. Somebody want to make the second one? October 25th at 6:30?
I'll make that motion.
Motion made by Commissioner Matus, seconded by Commissioner Exter, that we meet on the 25th.
And not on the
Yes,
18th,
25th of October,
and not on the 18th, to be
and
clear.
not on the 18th. Have to amend that part. All in favor, please say aye.
Aye.
Opposed, nay. The ayes have it. Good. Very good. If there isn't anything else, I will accept a motion to adjourn. Commissioner Mancini moves to adjourn. And seconded by Commissioner Exter. All in favor, please say aye. Opposed, nay. The ayes have it. Thank you all.